We are ready to get started. My name is Christina Lawson. I'm going to go ahead and call the Medical Board of California Panel B meeting to order. And I'm going to turn the meeting, we need to do roll call first.
Ms. Lawson?
Here.
Dr. Bolat?
Here.
Dr. Gonadev?
Here.
Dr. Kraus?
Present.
Dr. Levine? Ms. Pines?
Here.
Ms. Sutton-Wills? We have a quorum.
Thank you. I am now going to turn the meeting over to Administrative Law Judge Juliet Cox for oral argument on a non-adopted proposed decision.
Hi, good morning, everyone. I'm now opening our hearing, our oral argument in the matter of the accusation against Mahfouz Michael. This matter is Medical Board case number 800-2014-008-113. It's Office of Administrative Hearings matter number 2017-120-959. The hearing is occurring on January 18, 2018, beginning at approximately 8:30 in the morning in Milpitas, California, before Panel B of the Medical Board. I am Administrative Law Judge Juliet Cox, and I'll be presiding over this oral argument today. Let's begin with introductions by counsel for the parties, beginning with counsel for the complainant, please.
Good morning, Your Honor, members of the board. My name is David Carr, Deputy Attorney General, on behalf of complainant in this matter. Sorry.
Counsel?
Good morning, Your Honor. Craig Garner, on behalf of respondent, members of the board, thank you very much.
Good morning. Before we begin, I want to alert everyone that we do not, as is customary, have a stenographic reporter present here. It's my understanding that counsel for the parties have agreed to rely on the electronic recording of this hearing as a record of the arguments that are made and the questions and answers. I want to make sure before we continue that I have that understanding correct. Is that right, Mr. Carr?
It is, Your Honor. Thank you.
Mr.
Yes,
Garner?
Your Honor.
Okay. Then we will proceed. How we will proceed, as was stated on the hearing notice, is that we'll first hear opening argument from the respondent, either the respondent or his counsel, as you all have chosen. That will be 15 minutes, and I'll keep time for you. I'll permit the complainant then to make responsive argument also for 15 minutes, and I'll keep time again. Then we will trade off once more and allow closing argument from the respondent and the complainant for approximately 5 minutes each, and again, I'll keep time. What I'll invite you to do is to present your arguments. If you finish before your 15 minutes is up, that's certainly fine. And then I will invite questions from the panel here. Any of them may have questions to ask of each of you as you speak. So with that, you may begin, Mr. Garner.
Thank you very much, Your Honor. Once again, I am Craig Garner, and I represent the respondent in this matter. I invite the board to ask any questions as they come up. Feel free to interrupt if there's something that does come up while I'm speaking. I would like to just briefly start at the end of the administrative law judge's decision, and then from there I would like to continue keeping to the focus that has been requested about today. At the end of the decision, the administrative law judge notes that the penalty that she put forth in her record was that respondent should have educational possibilities but should not lose his license. It's not warranted given his, and I'll quote her, blemish-free 38-year career, not to mention the lack of evidence demonstrating that respondent benefited financially or professionally from his actions. And that was where she ended, and that's where I'm going to begin. The case was a 4-day trial, and it involved 6 different patients were at issue. And when I say at issue, I want to make it clear that there was never once a concern about patient care. This was not a case where the patients were in jeopardy, where the medical care that Dr. Michael or anyone in his office had provided was dangerous, was below the standard of care. It actually started previously with a concern about forms and documentation relating to immigration. And with respect to the evidence and respect to the penalty that was imposed, there are 3 points I'd like to make, and I'll state them now, then I'm going to go back and address them. The first one is I want to focus on the very nature of the investigation, how it began prior to becoming an accusation, which I think is important. It was an investigation that was handled internally, I believe, I think it was by the medical board, but it was with respect to the 6 patients at issue. Then I also want to talk about the testimony at trial. Of those 6 patients, one unfortunately is deceased, nothing to do with care, just no longer here. 2 of the witnesses, or 2 of the patients, were going to testify at trial, but unfortunately due to scheduling conflicts and testimony were unable to do so. And then there was 1 witness who was a patient who did testify. And the third, and I think most important, is the actual need for this clinic in the community and what this clinic does for the community. And that is in the record, and it is part of the evidence, and it does go to the penalty because the guidelines, the medical board disciplinary guidelines, are really just that, and I believe they're not meant to be interpreted as something akin to what I guess been referred to like federal sentencing guidelines, which are, these are meant to both benefit the physician and to protect patient care. And as the record is clear, there was not a concern of patient care. And so now we're talking about what's best for the community and what's necessary to address the issues that were raised. So I'd like to start now with the beginning of this investigation. There was a concern about documentation, and there was a concern raised about forms that were completed. And there were 6 individuals, and there was an allegation that they were given the opportunity to bypass part of the immigration examination through certain tests that they would be able to bypass if they were unable to, if they had memory deficit or certain issues that precluded them from being able to take the test in an ordinary manner. The information that was presented came through 2 investigators. There was a chief investigator, and then there was another investigator. The chief investigator was the one who testified at the actual trial. And so the way that this all kind of came about was these individuals were all marshaled into a room with one of the expert witnesses who testified at trial, one of the medical doctors, and then the agents who were armed, and these patients who really didn't know what they were doing there, and as the record states, even the doctor admitted, were pretty scared and didn't know what was going on. And it was in those circumstances that the information was put into the record. And the way this came about was the questions were asked, and the first investigator translated verbally. And then the chief investigator who testified took notes of what the translation said. And then from those notes, later, he transcribed them into what was supposed to be more or less a transcript of that meeting. And that was one of the issues we raised at the trial as sort of a fundamental flaw in the entire case, that the circumstances within which they were brought together, quite frankly, the fear of why they were brought there, not knowing what was going on, and the inherent bias, and I will not to say that the investigators did anything wrong, but I would still call it an inherent bias, and sort of the lack of continuity with respect to the translation. Here we have an audio recording, which is fine. Here we have kind of a person telling someone what was said, that person writing it down, then later from those notes translating it. That became the record. And that became the evidence with which the medical board filed its accusation. So all of that is the preliminary basis which formed this matter. And I think that while it was raised at the trial, I don't think it was given the credibility that it needs to, or that the judge truly understood the implications of it, because, quite frankly, in that context, in that small room, under those circumstances, if the expert for the medical board said they were scared, it means they were really scared. And I don't know, what circumstances, what they would have said or could have said, or how the questions were asked. I wasn't there, and that wasn't part of the record. So I want to just state that whole investigation started out kind of in a very strange manner, and that we took issue with that, and we raised it at the trial. As for the 6 patients, as I mentioned, one of them is no longer living. 2, we wanted to testify at trial, but were unable to make it due to issues with the case going longer on one side, but it was an unfortunate. One patient did testify, and as the record reflects, she did testify, and she took issue with, it first denied having any issues with her memory, and then acknowledged that she had issues for her memory for someone of her age, which nothing's wrong with that. And effectively, the medical board, the AG's office, put forth just one witness, one patient, whose medical record was actually consistent and accurate with respect to the documentation. There was also evidence put forth that she was concerned that if she was held to be impaired and not able to or have any disability of any sort, then she had risked losing money that she received each month because she cared for her husband. So she had a bias. So that was the only witness, the only testimony put forth by the petitioner in this case of the 6 patients. Granted, one is no longer around, and that was another significant issue because the records for that patient were accurate. The remaining testimony, which is, I think, most important, on behalf of respondent, was talking about the community and talking about what his clinic, Clinica Medica San Miguel, what it does for the community. I don't know if you're all from up north or down in Los Angeles, but it's in an area where it's needed, and there are thousands and thousands of patients who go to that clinic, and there are multiple locations, and they're open 24 hours a day, some of them, and yes, some of them have insurance, but some of them don't, and nobody has turned away, and so the absence of that clinic means that those same patients, if they get help, are going to have to go to, and this again was in the record, they would have to go to a hospital or to a local hospital and flood the emergency departments, which is already an issue. And the services that Dr. Michael and his clinic provides to the community are like no other. And I don't want that to be lost in the course of what's being discussed. Dr. Michael has seen hundreds of thousands of patients in his 38, I guess maybe coming upon 39-year career as a doctor. And although we take issue with these 6 patients that were brought up as concerns which gave rise to the accusation, we're talking about a pretty good track record by Dr. Michael. And I actually wasn't sure if you told me what time was left. I apologize, Your Honor.
I did not tell you that your time is up, that you have approximately 3 more minutes.
Okay, thank you. Sorry, I wasn't watching. But Dr. Michael, has done a pretty exceptional job in the community. And he's grown that clinic from nothing to what it is today. And that was part of the reason why I believe, or at least one of the reasons why the judge, the administrative law judge, made her decision. But I think that yes, do we disagree with what the proposed penalty should be? We do, of course. That's why we're here. We asked for oral argument. And if you're wondering which direction we think we're going, we think it should be less. I guess that's probably self-evident. But I will reserve the last 2 minutes for questions. I know that I will have 5 minutes at the end, or 5, is it? 5 at the end. But if you have any questions, I would be happy to answer them, as well as at the end of the 5 minutes. But I do want the, with respect to all the things going on in healthcare today, healthcare reform, all the changes, this clinic is there, and it's a beacon, and it does not want to go away, and it's not planning on going away. Thank you very much.
Are there any questions from the panel?
Yeah, later, not at this time.
All right. Then we'll turn it over to Mr. Carr.
Thank you, Your Honor. Members of the board, the disciplinary guidelines that have been formulated and that apply in this case and all other disciplinary matters before you are not a random assembly of possible alternative dispositions to fit one size or all sizes. They are the product of years, of decades of experience, knowledge, and focused intent to create both a series of protections when discipline is warranted for the public and to ensure rehabilitation of that physician when that rehabilitation is not inconsistent with protection of the public. The record before you, most particularly the proposed decision, sets forth the factual and legal basis for imposing discipline. Good cause was found to exist based on the evidence presented at hearing, a full and fair 4-day hearing, to find that complainant met the burden of proving that Dr. Michael had engaged in acts of negligence, both extreme and repeated, that he had failed to maintain accurate and adequate medical records as to these 6 patients, and that he had engaged in a knowing misrepresentation of pertinent facts, which is probably the point of greatest concern for the board. The disciplinary guidelines call for a minimum for a violation of BNP section 2261, which is the knowing misrepresentation of facts, of a 60-day suspension. That was not imposed here because, as Mr. Garner points out, the judge found there were 2 factors in mitigation and cites those 2 as being a 38-year blemish-free career and that there was no proof adduced at hearing that Dr. Michael had benefited personally, professionally, or pecuniarily from his conduct. The latter of those, that no proof could be shown that he benefited economically or professionally, is irrelevant to this proceeding. We don't know his motivation for attesting under penalty of perjury to the facts that were proved to be misrepresentations on the federal forms he filed. We do know that he did file them under penalty of perjury, and that it was a product of his medical care or supervision of medical care to these 6 patients. That he didn't profit immediately or obviously from this is not a relevant concern because we cannot understand or know the motives behind it because they weren't produced. We don't know that. The 38-year blemish-free career is a presumption. Most physicians in California manage to practice the entirety of their career without incurring discipline, without crossing the medical board's boundaries for professional conduct. That in itself is not a plus. That is a given. It's assumed. It's what should be the normal course. It is the exception as taken into consideration, and the court gave, I believe, undue weight to that in finding that that alone was a point of mitigation. It is not. The disciplinary guidelines are set up, as we said, to protect the public, to afford rehabilitation where possible. They assume that the physician has not before been engaged in professional conduct, not found to have been so. And that's the starting point. To give extra points for not having been found to violate in the past is inappropriate, and in this case, they do a violation to the board's mandate and objective in having these disciplinary guidelines. The guidelines, of course, as set out, provide some aspects that can be termed punitive. A suspension is, on its face, a punitive act. It is, however, necessary when it sends a message not only to the physician in question, but to all physicians in California, that these are the standards that must be upheld, and there are consequences for violating them. When we lose that sense of important precedence, when we surrender it in order to try to make it fit a particular case, we lose the value of the rule of law. And in this case, as well as all others, that is essential. The board's desire to do justice and do right in every particular case is best served by looking at the facts of the case and then judiciously applying the disciplinary guidelines. The guidelines, at a minimum in this case, at a minimum, call for a 60-day suspension period and for a period of probation. The other conditions imposed by the administrative law judge were carefully crafted to ensure rehabilitation. I beg your pardon. To the extent that we can do so without, again, endangering the public. There is nothing punitive about any of the other aspects here. But again, the necessary aspect of imposing a foreseeable and appropriate consequence is contemplated by the guidelines and is an essential component of the board doing its mandate. Based on that, I would ask the court to adopt the decision. I would ask the board to adopt the decision with the imposition of an appropriate period of suspension if you believe probation is appropriate in Dr. Michael's case. The other alternative, of course, is that if, by review of the record, you find that his conduct is sufficiently egregious that the public is protected only if there's revocation in this case, then that would be also an appropriate disposition as contemplated by the disciplinary guidelines. Based on those guidelines, we'd ask the court to increase the penalty at a minimum to impose a period of suspension, of actual suspension on Dr. Michael's practice, and, if appropriate, to revoke this license until he can demonstrate a suitable fitness for practice at some point in the future. On that, I would submit.
All right, are there any questions for from the panel? No? Hearing none? All right, hearing none, I will turn the floor back over to Mr. Garner.
Thank you, Your Honor.
Additional 5 minutes.
I just wanted to note, with respect to the medical board's disciplinary guidelines, which is under Business and Profession Code, and by the way, I've submitted this in our brief, so I'm not going to belabor it. I believe if you haven't had a chance, you have copies of it. It states that the guidelines mandate protection of the public and it shall be the highest priority for the medical board and for the administrative law judges of the medical quality hearing panel. And that's the issue that, I want to start and end with, is that the protection of the public, and that while we are arguing that a lesser penalty is appropriate, just to respond to counsel, a suspension of his license in this particular instance relating to 6 patients out of the hundreds of thousands of patients that he's seen, 6 patients who he saw several years ago, or excuse me, the acts about which this is happening he saw several years ago, the patients who he still sees or he has seen after the events which occurred, who come to him as his physician, and there are no issues. They like him as his doctor. He takes good care of them. It's not an issue of needing to be suspended to rehabilitate. It's an issue that is no longer. And then with respect to the evidentiary concerns that I've raised, again, the burden of proof it's a clear and convincing standard, which has also been briefed. It's the middle. It's not preponderance of the evidence. It's not beyond a reasonable doubt. And the presumption of a blemish-free career, I suppose, which I understand. Certainly, as an attorney, it'd be nice to assume all attorneys are good, and I want to assume that all doctors are good. But the medical board is here today for a couple of days, and I'm assuming you're going to be talking about issues that are involving medicine in general. And I know if I read the paper, there are lots of things that are going on. And I don't know if these issues that we're discussing here today are on that list. I know what issues are in the news, and the nice thing is those issues aren't at issue in this case. This is not a case about opioids. This is not a case about dependency concerns. This is a very discrete issue, discrete in the sense of we're talking about the facts, at least, are very well ensconced into a very small compartment of issues. So I don't believe that it's going to be of discussion after the hearing in that regard. With that, again, I do think that it's not just the 38-year career that the judge focused on. It's what he accomplished in that 38-year career. And that is Clínica Médica San Miguel. And that is what that stands for. Because that is Dr. Michael. And that's what he did in that 38-year career. And with that, Your Honor, I rest.
Again, are there any questions from the panel for Mr. Garner? All right, hearing none. Mr. Carr, do you have anything further to say in your last 5 minutes?
No, Your Honor. I will avail myself of this opportunity to answer any questions the board may have, but nothing additional to offer to the board at this time.
Your Honor.
Yes, Dr. Kennedy.
If you feel it's appropriate, I will like to ask Dr. Michael a couple questions. Number one is your clinic FQHC?
Hang on. I haven't sworn Dr. Michael to answer questions, and I can.
Yeah.
This proceeding is not one in which the board should be receiving any additional evidence that is not in the record. So it might be, if you'd like to know the answer to that question, or whether the answer to that question is already in the evidentiary record, that may be something that Mr. Garner or Mr. Carr can answer.
And I don't know if it's in the record. I can probably in about 10 seconds stipulate with counsel that it is not an FQHC, and I don't know if you know, but we can certainly talk outside, but it is not an FQHC. Is that correct?
I call our clinics.
You need to swear.
Yes or no? Is an FQHC?
Shall I swear your clients to tell the truth and he can answer
it's-
the question, or?
Your Honor, I apologize.
Is the answer to the question in the record? I guess that's the first question for you.
I don't believe the answer to the question is in the record.
So it didn't come up in the hearing?
Correct. And I don't know for a fact, but I can certainly check afterward before. I don't believe, I certainly am familiar with FQHCs, and I do not believe it is actually a bona fide FQHC.
Thank you. And the second one is this Form 648. Does he have plans? The entire case is about 648. Does he have plans to change how he deals with it? Which should be in the record anyway. That's what the case is about.
Does the record address that question?
The record does address that, Your Honor, and I don't believe there's anything new to add, and I would refer to the record, or defer to the record on that, Your Honor.
Do you have handy any information for the panel about where precisely in the record to find any testimony your client might have given on that point?
I don't know if it came from my client or from someone from his office, but the testimony was that is no longer that procedure, that process was stopped long ago, and there is no longer anything done in that regard. It stopped a long time ago. When I say a long time ago, it was at least a few years ago.
Are there any other questions from any of the panel members? All right, hearing none, then that will conclude our presentation this morning. Thank you very much, and this hearing for oral argument on this accusation is now concluded.
Thank you, Your Honor. Members of the board, thank you very much.